first that no, I didn't want to do it, and I said, well, we want you in there, and we want you because you particularly understand the way our logic is flowing here. Every scientist explains this, looks at this subject somewhat differently. I agree particularly with the way that this was presented to the court, and I think it's a very strong approach. I think it's a good way to go because the court can look at something exceedingly simple. This sort of science is presented to the public as so well established as to be, or so simple as to be self-evident, but it is then also so complex that we need these massive computer models to simulate it, and that difference is problematical because it can't be both. But in fact, we address that here with these 3 lines of evidence that we present in this brief and take those apart. Each are fatally flawed, and we can do it in a very simple, logical fashion that the court will likely understand.
Well, and I very much agree with you, too, on that point, is that so many times when this is discussed in the press, is that it's portrayed as just incredibly complex science, and you just wouldn't understand it. So you basically have to take our word for it. So I definitely agree with you on that one. Within your...
And Mark, we can go from there and say, okay, let's agree with you that it is extremely complex and we don't understand all of it. In other words, the computer models are a black box of sorts. How do we test that? Well, you give us the output, you give us the predictions for the future, and we'll test that against the data that we collect over a period of time or already have collected, and then we can see if your miracle that is supposed to understand all of this, however complex it is, whatever it goes into, does it match reality? And the fact is it does not.
Well, and of course the other part of that, too, is that if it's so complex and you're depending on those computer models to essentially interpret it for you, then you're completely dependent, trusting the people that are putting that data in.
Very much, yes, that's very true. And this trust us business is not part of science. Neither is consensus, neither is authority. It's all a matter of robust evidence and careful logic. That's the scientific method. That's the beginning and the end of science was the scientific method.
Yep. Within your brief, it reads, quote, that the 3 lines of evidence from the administrative record that the EPA relied on do not support the conclusion that man-made greenhouse gas emissions have caused global warming. So what are those 3 lines of evidence?
Well, first of all, the EPA concluded with near absolute certainty that temperatures in the second half of the 20th century were unusually high because of greenhouse gases. Near absolute certainty. Well, that's something that you really can't claim with anything about climate, but they claim that. They also claim that they have identified the signature of greenhouse gases in the tropical troposphere, a hot spot, and then they claim that their computer codes involve all of the complexity here and can properly forecast the future out 100 years. Well, I can show very easily, and we have showed that they can't even do it out a decade, and that's the principal problem. But what about the temperatures being unusual in the latter half of the 20th century? We have seen repeatedly up until maybe a few years ago claims that every year is hotter than the last year, and we're inexorably headed toward a catastrophe of some sort. Well, the truth is that after the Second World War, temperatures were, depending on what data you look at, were essentially stable for 3 decades or declined a little bit. And then as of about 1977, there was an increase in temperature. And then for the last some number of years, there hasn't been any net increase. There's been a lot of variation month to month, but not any net increase. And where were we? What was the state of the climate last month? Let's just give the weather report here. It was 7/100ths of 1 degree above the 30-year average. In other words, as close to normal as you'll ever find it. But what about further back? These claims of the hottest year and various implications that each year is hotter than the previous one. You notice that has stopped. And what has it been replaced with? Well, or what has stopped them there would be a better way to ask that. And what you do is you look at the various data sets here, the really good ones, the satellite data, show no statistically significant increase in the global temperature for as much as 23 years. The more problematical data sets from the surface records are the ones that have been consistently doctored in some ways, and where the original data has in some ways been destroyed, still show over the last, say, 18, 19 years, no statistically significant increase in the global temperature. So everybody is now changing their tune, except those who haven't gotten the message at all. You have James Hansen, whom we talked about before, my astrophysics colleague. You have Phil Jones at the University of East Anglia, of ClimateGate fame, a famous professor there, saying, well, the temperature hasn't done anything in the way of a trend in the last number of years. You have even New York Times. You have the mainstream media that's been heavily into this we're burning up sort of scenario, now saying, well, nothing's been happening for a period of time. So once you have those sorts of admissions, the EPA's claim that temperatures are unusually high or there are other unusual things going on, is simply dead in the water, which means that whatever explanation you give to that is itself invalid. Carbon dioxide is missing in action at that point. What about the hotspot? Well, this is supposed to be an increased warming in the tropical troposphere, mid-tropical troposphere, 12-kilometer altitude. Is that observed? No. Multiple robust data sets show that over the last, let's say, 30 years or so, where we have good data, the satellites and the radiosondes show no increase at all, let alone an increase higher up in the troposphere that these greenhouse gases are supposed to have produced. So that line of evidence or line of argument from the EPA is fatally flawed. It is simply not there. And their computer codes basically rely on this. That's the physical basis of the computer codes. But let's say that they somehow pull it off being so right in everything else that they can predict the future. Well, somebody very recently, and this is very, very recent here, has looked at the how the computer codes compare with the actual observations. And what it comes out is that they are off by a factor of 2 to 3.5, depending on who's doing the compilation. 73 climate models, and they're all showing much more warming of the atmosphere than has occurred. And that's remarkably bad. Now, is that just what we're saying, or is that what others are saying? And if you look at a recent report by climate alarmists in the Proceedings of the National Academy of Sciences, but hidden very much at the back of the report, they say that they're off by a factor of 2. That's huge. That says that their computer code is just not able to manage it.
That is huge. We're talking today to Dr. Gordon Fulks. He is part of a group of scientists who have filed an amicus curiae brief as part of the Southeastern Legal Foundation's lawsuit against the EPA. The brief challenges the science being used by the EPA to arrive at their endangerment finding on carbon dioxide. And, Dr. Fulks, in a 2012 blog posting for Australia's No Carbon Tax Climate Skeptics Party, you wrote, quote, hence the fundamental issue for me is the survival of science as an objective profession. Continuous spin from highly political non-scientists does not help, and complicity among many scientists who want the government grants to continue is very destructive. So I'm curious, if you win your argument before the Supreme Court, what effects do you think that win will have on the scientific community?
Well, it hopefully will lead eventually to the end of this hysteria-driven science, where science has to be so pertinent to societal problems that that's the only type of science that you do. You really want to do science that looks into basic issues that may not be of immediate importance. And you want to make sure that the government agencies haven't told the scientists what conclusions they want and are paying them for those conclusions. Conflict of interest is a huge problem at this point. And it is not something that is particularly new. Dwight Eisenhower, in his famous departure speech from the presidency about 50 years ago, talked about a scientific technological elite that would hold the public captive here, telling them particular things and leading them in particular directions for their own benefit. And that's exactly what has happened here. We have to get beyond that. Science is the one great hope of mankind, but only if it remains objective, and it certainly has not here.
I guess the flip side of that is, then, what if you lose? Do you think this will further empower scientists who are already accepting these government grants? I mean, I could just see where this is a disaster, where you've got these, as you say, government agencies essentially telling the scientists what they want them to find.
Mark, it's already a disaster. I'm not sure that it can get much worse. Science has turned essentially to astrology. You have all of these unusual incidents, supposedly unusual incidents in the weather that get attributed to global warming, to carbon dioxide, without any proof at all. That's not science. That's astrology. It's something that it can't get much worse at this point. If we lose, or let's say the immediate issue here is whether the Supreme Court will take up this issue. If they don't take it up and the EPA gets its way, then the immediate effect that the public will notice is that regulations will be forthcoming that are very onerous, the worst regulatory environment that we have ever seen, and that's what people should be particularly concerned about. But yes, my concerns will always come back to the science and how can we get this back to an objective profession.
You know, so much of this is just money-driven. Big corporations and big political donors stand to make hundreds of millions of dollars off of cap-and-trade schemes, costing ratepayers, as you say, thousands of dollars per year. You know, unfortunately, universities really are, in my view, somewhat tainted by the vast amount of funds being funneled to them by federal and state governments that have a vested interest in fostering the belief that global warming is occurring. So have you given any thought really to how we can divest universities of that tainted money? And then secondly, what's the impact of all of this, you think, on recruiting the next generation of scholars into science?
Well, how do you wean universities from hundreds of millions of dollars that they now depend on, not only for the scientists, but for the vast army of folks they have living off of that, who are the administrators and so on? They become totally addicted to the government money, and without that, their whole economic structure would collapse. So it pretty much has to continue. And at least from their perspective, what really needs to happen, though, is we need to go back to the old arrangement where universities didn't have an awful lot of money, professors weren't paid huge salaries, and were not held captive by the political folks who wanted results that matched what they were saying. So we have to get away from that. And what was your second question there?
Well, I was just curious what you think the impact of all of this may have on recruiting the next generation of scholars into science.
Well, the next generation of scholars have been raised from kindergarten to regard the climate hysteria as true and not question it. So they are even worse than the generation of professors in there who are teaching it to them. So this whole thing needs to be turned around, and as I said, I'm not sure that it could get much worse. It is truly terrible at this point and not objective at all. How do you get that back to being objective? I think you cut off a certain amount of the funding. You reduce you certainly don't pay people to come up with results that you want. And that is just blatant corruption.
Yeah.
We've seen enough of that.
And I don't think it's going to happen all in one chunk, but we can at least start turning the boat in that direction. Just real quick, we got about 30 seconds, so real quick before we need to go. Are you going to be in court when the oral arguments are made? If this gets to the Supreme Court, are you going to be an expert witness?
I don't think so. I'm not sure how that will proceed. I am relatively new at this. Why don't you ask your next guest how that works? I will be interested also. Let me know.
We will do that. All right. Well, thank you so much, Dr. Fulks. It's always great to talk to you.
Thank you for having me.
I'd like to welcome now Shannon Goessling. She is the Executive Director for the Southeastern Legal Foundation, an Atlanta, Georgia-based public interest law firm and policy center, or as I like to think of them, they're the heritage foundation of the legal world. Shannon, it's good to talk to you again.
Thanks so much for having me on.
Absolutely. You know, the far-left group Center for Media and Democracy's splinter organization SourceWatch says the Southeastern Legal Foundation is a nonprofit law firm which is closely affiliated with right-wing advocacy groups and global warming skeptics groups. Ooh, that's so scary. Does that frighten you at all?
No, not at all. I mean, that's like a compliment, right? You wear that as a badge.
Really. Before we get going, we had asked Dr. Fulks if he would be in court during oral arguments and whether or not he'd be called on as an expert witness. And he said, I don't know. I want you to ask Shannon about that. So we're asking you.
Yeah, sure. The answer is no. He is, of course, we would be thrilled with the scientists who filed the amici brief in support of our petition to be there for oral argument. That assumes that the court will grant the petition. We would be honored to have them present and hearing the arguments that we make that speak to their concerns. And but there is no testimony when you make oral argument to the United States Supreme Court.
Okay, well, that's...
Yeah, the record is actually closed. It's kind of interesting. I mean, most people think about, they think of a trial, and then they think you get to go to the court and you get to do these things, but really, it's any case that actually goes to the United States Supreme Court, it's called the record is closed. It's a finite period. That's the only thing that the court will look at. And lots of times they won't even look at the record. They'll be reading the brief and not even pull the record from a lower court. But you do have a small number of cases are granted, and a smaller number of those are actually granted oral argument, and that means you have an advocate standing at the lectern speaking to the members of the highest court in the land. It's a great honor.
Wow, that does sound like an awesome honor. A couple of weeks back when I was in residency, we replayed your interview from about a year ago regarding your experience at the District of Columbia Court of Appeals. Can you kind of recap that and the path that you took to get there?
Sure, yeah. Back in 2009, Southeastern Legal Foundation got involved and started what we call our Global Warming Litigation Project. We were seriously concerned about what this administration was doing. Generally, I'm very concerned about announcements that were coming out of the court and what we expected to be rules and what we expected to be the finding, which was the endangerment finding. And as a direct result of the Environmental Protection Agency issuing the endangerment finding after there were over 6,000 comments, basically telling the EPA that there was not endangerment, they should not make the finding, and they should not then go forward with all the rulemaking. They did it anyway, and Southeastern Legal Foundation, on behalf of 14 members of Congress and 15 business associations, and on behalf of itself as a public interest advocacy center, filed suit in each of the cases, including the endangerment finding. We went to the D.C. Court of Appeals, which is where the case goes, and we had oral argument in February of last year, and it took all the way until December of last year to actually get a decision telling us affirming the decision, but getting us also two judges on the panel to dissent. So we got a decision that was basically three judges saying, no, all of your cases are either not right, they don't have standing, or we agree with the EPA. So it was a loser across the board for every single petitioner. The many, many thousands of people and hundreds of organizations represented in this action got basically a slap down. We asked for a rehearing and rehearing en banc. We were denied that, but there were two phenomenal dissents, which if people don't know what a dissent is, there's a majority opinion, and then judges can say, I disagree with the majority opinion, and let me tell you all the reasons why. And we had two judges who said, we disagree with not granting it, and these are all the reasons why. And from that opinion in December, we filed our petition for writ of cert to the United States Supreme Court, asking the United States Supreme Court to take our case.
Well, how important are those dissenting opinions in order to get that before the Supreme Court?
I tell you what, in this particular case, it's exceedingly important because it is a voluminous record. It is a record that there isn't a single judge. They even admitted it at the oral argument mark that basically not dissimilar to Obamacare. You didn't expect us to read that, did you? So literally you have a record that no one will ever read. And you're arguing about what's in the record, what's not in the record. But it was very important. It was key to grounding the reasons for the court to grant the petition. I mean, Judge Kavanaugh and Judge Brown really laid it out there, explaining what the deficiencies were, what was wrong with the panel decision that affirmed the Environmental Protection Agency's decision to rulemaking here.
You talked a little bit earlier about the honor it is to go before the Supreme Court like that. What is the preparation like that? I mean, that's got to be really daunting in a way.
Well, think about it this way. One in between 7,000 and 10,000 cases are granted a petition. So 10,000 cases will be filed, and one case will be granted the opportunity to have it heard by the Supreme Court. So that puts it into a very elite category. And then, we're not even at the merit stages. There's the petition stage, which people probably know. It's basically a document that tells the court, please take our case and let me tell you all the reasons why this case is special and why you should grant, because it's all discretionary. Then, if the court grants your petition, grants you a writ of certiorari, is what it's called, you then have to file a merits brief telling the court on the merits why the decision, for us, we're petitioners, why the decision of the D.C. Court of Appeals was wrong and why the United States Supreme Court should reverse that decision. And then it's a whole nother level when you're talking about oral argument, because then you have, I guess put it in context, 9 of the smartest people on the planet are going to pepper you with questions for 20 minutes.
Wow.
About whatever it is that they want to talk about. I mean, if anybody listened to the Obamacare, or even any of the Second Amendment cases, there's been very limited circumstances where the United States Supreme Court would run the oral arguments live. And if you remember, the types of questions that could be asked could be anything that they feel like they want to talk about.
Sure.
That's what you have to be prepared for. It's an amazing effort that has to be taken.
You have no idea where those questions are coming from, too. Just real quick, so are you going to be the one doing the oral arguments?
That is up in the air. I have to be honest. The number of petitioners, the number of petitions, it will all have to do with what the question presented is going to be. We suggest the questions to the court, but it's the court's decision. So because you have 9 petitions going before the court, all on these topics, you may have a single advocate. You may have more than one advocate. It's all up in the air, and there are some phenomenal oral advocates on our side that have been before the United States Supreme Court. And to be fair to me, I'm not one of them. I've never made an argument to the U.S. Supreme Court. My theory is you always have your first chance, right?
That's right. You got to go first sometime.
It's more important. Ego is the last thing in the world when you have an opportunity to make a difference for our country.
Yeah.
And you put ego aside and you put opportunity aside and you make the decision that's the very best decision for the case. And that's what we'll do.
That's why we like you, Shannon. You're there for the team. That's awesome. Gordon has said that nobody's really challenged the science of global warming before. Is that correct? It just seems
it's pretty correct. It's kind of odd because, there's never been a hearing. Everybody expects a trial. There has not been a full hearing in front of a jury or a court on the science of global warming. I think that that's an accurate statement. And Massachusetts versus EPA certainly did not do it, even from an administrative standpoint. But this case, from an administrative record standpoint, that is what Southeastern Legal Foundation is trying to do with our petition, with our case.
And the reason I ask that is just because, from a manager's standpoint, you look at that and you think, how do you make this kind of a big decision and not challenge the underlying beliefs on something?
Right. And I have to tell you, there are some really phenomenal legal arguments, and we've made some of them, actually, a lot of the original petitioners have made them, including Southeastern Legal Foundation on behalf of its petitioners, and we've also made them in our petition. But imagine standing before the United States Supreme Court and then saying to any advocate, I understand that, the science has been waived, so that's an issue, so you basically admit that the EPA is right. I mean, can you imagine after all these years of us saying the science is wrong, the science is premised on fraud, Climate Gate, Amazon Gate, Himalaya Gate, I mean, the fiasco of the IPCC. Can you imagine standing there and having that be the record? Southeastern Legal Foundation, we could not have that happen. I absolutely refuse, even if it is the toughest argument, even if it's the one that causes us to work the hardest, climb the highest mountain, have the least chance of winning. We've got to stand there in front of the United States Supreme Court, in front of the American people, and say the science is bad.
Well, I just, and I absolutely agree with you on that, because I just think that this is potentially disastrous if it's not challenged, because otherwise you've essentially got the EPA or whatever government bureaucrat suddenly saying, well, we're going to use this science that's basically made up over here, and we're going to have all of these rulings now on top of this.
Right. And it's a tough hurdle. I mean, people, they may not understand the legal burden, but it's a tough hurdle because of the discretion and the deference that the courts grant to administrative agencies. But hey, it's called abuse of discretion,
yes,
right? It's
yes.
called that for a reason, and that's what this is. And they don't have a foundation. The rules do not have a foundation upon which we should be satisfied that they rely. American people should be very dissatisfied, and that is regardless of whether you believe in anthropogenic global warming, whether you believe carbon emissions from the American people are causing it. It doesn't matter what your belief system is about that. It has to do with process, procedure, and the rule of law. If they get away with it now, there's nothing that will stop them. And that's why I have to tell you, it's so important that the liberal, conservative, Democrat, independent, Republican should see. Imagine you're an administration you totally believe in, doing something from a policy standpoint you totally believe, but they do it in a way that's illegal, violates due process, violates separation of powers, executive fiat, no congressional involvement, violation of congressional intent. Imagine all of that, and you go, oh, but it's okay because I totally believe in that policy. Guess what? 10 years, 20 years down the road, when the administration is not your administration of choice, and they go to do something you don't like, and they're going to look back and say, see, I get to do whatever I want.
Yeah. Well,
that's the important part here.
Yep, exactly. And so much of it is really trust. I mean, we're seeing so much of that nowadays in the news, with whether it's the IRS scandal or the NSA scandal. I mean, we're just not able to trust our government. And now they're once again asking us, we've come to this conclusion, now trust us that the science that supports it is good.
Can't do it.
Yep.
Just can't do it. Can't do it. Couldn't do it 4 years ago. Can't do it today. And will not allow from here until eternity for somebody to say, see, nobody challenged the science. Just can't let that happen.
Well, talk to us about that process, really, of making that argument successful. I mean, because does it get down to a kind of a he said, she said sort of thing, where our scientist says one thing and their scientist says another? Talk to us about making that argument.
I have to tell you, it isn't that. It's a fundamental legal question about what level of discretion, and then also critiquing exactly what the Environmental Protection Agency used. So we, knowing we have a short time frame, it's going to be short attention span, right? You heard Dr. Fulks. I mean, right, brilliant. Well, the number of scientists that joined the brief that he was on, I mean, these guys are brilliant. They live this stuff. They understand it. But now what we're doing is we're writing for United States Supreme Court justices and their clerks, a bunch of lawyers, right?
Yeah, who don't have that training.
We got to lay it out for them. So we started out with a huge brief, and we just started attacking it and critiquing it and getting it to a point where it was easily understood, it was grounded in fact, it demonstrated the abuse of discretion, it demonstrated that it was arbitrary and capricious when it came to the decision-making about the science, that it was a disregard of known facts and known records. So we just really had to take the time to say, what is it that we can say in the amount of time that we can say it, and get our audience to understand the problem, and that it is a fundamental problem, and that it demonstrates, executive abuse, contrary to the rule of law.
And what a process, too, that we're making such big decisions on trying to get a few sentences crammed in. Really amazing stuff. It's been a very full show today on the iSpy Radio Show. We're talking right now with Shannon Goessling. She's the executive director for the Southeastern Legal Foundation as they're getting ready to take the EPA to the Supreme Court. Shannon, just three real quick questions. First of all, who are you guys up against? I mean, is it going to be the same people that made the oral arguments back at the appellate court level?
Well, I don't know who's going to make the argument, but yeah, it's all the same. It's the environmentalists, the global warming activists, and the Environmental Protection Agency attorneys and Department of Justice. So it's a whole cadre of folks.
Okay. And then I guess this boils down to what essentially are you asking for from the Supreme Court? In other words, if they rule in your favor, does that mean that they agree that the science is flawed, or does it mean that it goes back for further review? What will be the outcome of this if they rule in your favor?
Well, we would hope that they would stay the rules, that they would reverse outright the D.C. Court of Appeals, and that they would remand to the D.C. Court of Appeals and or the Environmental Protection Agency for the various violations. But certainly we want a declaration that the Environmental Protection Agency violated the law when they rewrote or they created the tailoring rule, when they changed the stationary source emission limits. So that, I mean, there's a multitude. It's so complex, but basically we're looking for a stay. So these rules will stop being in effect, reverse the EPA outright. I would love that. But we'd take a remand, which is a return to the EPA.
So basically, if I'm hearing you right, what that means then is if the Supreme Court rules in your favor, that essentially the EPA then goes back to the drawing board and they then rewrite the rules once again.
It's potential. I mean, look, if you're asking me, what is my greatest gift? My greatest gift from the United States Supreme Court would be a reversal on the endangerment finding. That they would say it was an abuse of discretion, it was arbitrary and capricious, and they do not have the authority to issue the endangerment finding. And if that occurred, that would be a phenomenal gift to me and the entire country, and all rules would fall. Whether that will happen or not, I don't know, but that would certainly be what we would hope for. That's an ideal world. I just don't know that the ideal is possible.
Boy, that sure.
But we're fighting for it.
That sure would be a huge gift to the country, because, and I'm just so tired of looking at this administration. It is just so due for a slapdown that I keep hoping that the Supreme Court will assert their authority and say, you guys, you're not acting within the bounds of the Constitution. You're not acting within the bounds of how this has been established. And I'm just praying for that.
Yes, absolutely. Every single day. And you just never know. We could certainly get lucky. The type of abuses that the Supreme Court has had to take issue with this administration, it might just be that the ideal, from our perspective, can happen. And it may very well happen. And certainly when they have just run so far afield of the decision of Mass versus EPA, I mean, them relying on the decision of Massachusetts versus EPA for everything they're doing, I would love for the United States Supreme Court to say, wait a second, I read that. Not only did I read it, I wrote it. And that's not what we said. I mean, that's truly what they should be doing. They should be saying, you don't get to take our words, twist them around, and do whatever you want to do. That's not what you get to do with what we write. And it would be, it would just be phenomenal.
We got about 30 seconds here. Just real quick, what's your best guess?
My best guess is that the petitions are going to be granted, and that, that we would hopefully get a 5-4 opinion that, certainly reverses the tailoring rule and maybe gets us some good language on the science issue and some issues related to how there's been a misinterpretation and misunderstanding of the decision of Massachusetts versus EPA. But we won't know that probably for 6 months to a year. But that's what we're working for every single day. That's how we spend our time.
Well, Shannon, it's our time's up with you, but boy, we sure wish you absolutely all the best.
Thank you so much. I appreciate you having me on.
I do not believe in a fate that will fall on us no matter what we do. I do believe in a fate that will fall on us if we do nothing.
It's not just a show, it's self-defense. The I Spy on Salem radio show.